Senate Bill 443 by Senator Mitchell and others, enacting relating to forfeiture.
Mr. Hadley, you're recognized.
Thank you, Mr. Speaker. Members, we have today the opportunity to restore a core principle of American justice, and that is that no person's property can be taken from him or her without due process of law, without a trial and a conviction. In California, in the last 20 years, tens of thousands of people have had property taken, and that property has not been returned, even though those individuals have neither been charged with a crime nor convicted of a crime. Nationally, this is a big issue. The Washington Post pulled 43,000 records from the U.S. Department of Justice under the Freedom of Information Act related to asset seizures, and on those 43,000 records, 81% of them involved property that was taken without an indictment ever being filed, and we're talking about over $2.5 billion. So this is a big problem, ladies and gentlemen. What SB 443 does is it simply asks California law enforcement to adhere to what is today good California law. Under California law today, no person's property can be taken without a conviction. What SB 443 does is it restricts law enforcement from partnering with federal authorities to take that property and split those assets under federal jurisdiction. That is what SB 443 seeks to end. We're not trying to change California law. We're trying to make sure that asset forfeiture happens in California under California law. Let me tell you what this bill doesn't do. This bill does not break federal law or federal policy. Both the U.S. Department of Justice and the U.S. Treasury have informed Senator Mitchell and my office that there is nothing in this bill that conflicts with federal law and federal policy as it relates to the ability of federal law enforcement authorities to work with state and local authorities. If SB 443 passes, the state of California will still be in compliance with federal law. This is an issue that commands broad support, bipartisan support across the country and across California. Polls show that over 75% of all Californians and within both parties support reforming federal asset forfeiture reform. Groups as diverse as the Heritage Foundation, the ACLU, the Institute for Justice have all come out in favor of federal asset forfeiture reform. And we have before us the opportunity to restore this core principle of American justice. Ladies and gentlemen, I request your aye vote on SB 443.
Mr. Jones Sawyer, recognized.
Thank you, Mr. Speaker. People who have not been charged with or convicted of a crime should not have their money or property taken and permanently kept by law enforcement. It's a gross miscarriage of justice, and it must be stopped. There have been a lot of hyperbole and bending of the facts by the opposition that I'd like to address. First, the opposition has said that they will not be able to participate in local, state, federal task forces moving forward. But if you read the bill, you'll see that that is not true. With your permission, Mr. Speaker, I'd like to read from the bill from Section 2A.
Without objection.
Nothing in this section shall be construed to prohibit the federal government or any agencies or any of its agencies from seizing property, seeking forfeiture from under federal law, or sharing federally forfeited property with state or local law enforcement agencies when those state or local agencies work with federal agencies in joint investigations arising out of federal law or federal joint task forces comprised of federal and state or local agencies. Also, the opposition has said that officials of the U.S. Department of Justice and the U.S. Treasury have said that SB 443 will put California out of compliance with U.S. law, and therefore there will be no income from federal forfeitures in California. That is not true. That is not even close to the truth. If I may read again, once again, from an email from U.S. DOJ official that was delivered to both the California District Attorneys Association and to the office of Senator Mitchell regarding SB 443. Mr. Speaker.
Without objection.
This proposal does not violate the statutes or policy governing the Department of Justice Equitable Sharing Program, and the AFMLS would not deem California agencies ineligible as a result of these provisions. As the budget of Sub-Chair for Public Safety, I believe strongly in providing law enforcement agencies what they need to do their jobs and to keep our communities safe. And I believe very, very strongly in good pay for the work that police and deputies do. It's dangerous work and vital to the well-being of our communities, so I will keep standing up for the rank and file. I cannot, however, in good conscience, support a policy of taking money from innocent people to pad their budgets. It's fundamentally wrong, and it needs to be fixed, and it needs to be fixed now. I also would like to thank Mr. Hadley for working across the aisle on this fundamental reform. I respectfully ask for your aye vote.
Mr. Wagner, you're recognized.
Thank you, Mr. Speaker. I am rising in honestly quite reluctant opposition to this bill. I think that Senator Mitchell and the proponents of reform of asset forfeiture are absolutely on the right track. There are examples out there that my friend from LA has talked about. There are examples that we read just yesterday in the San Diego Union Tribune in a very cogent article by Stephen Greenhut explaining the nub of the problem. It's truly there, and it would be a credit to this body to address it. The problem, I think, with this bill, and the reason I finally came to oppose it, is that we do have a couple of core principles here. We shouldn't be seizing and keeping the property of innocent people. Fortunately, after an opportunity to discuss this with my district attorney and one of his chief deputies in some detail, it's clear to me that that core principle, if it's violated, is violated in much more of a random ad hoc basis rather than a wholesale disregard of a core American principle by our law enforcement agencies. We need to make sure that our district attorneys and our police agencies have the tools to go after the real bad guys and make sure they don't abuse those tools. The problem with this bill is, in my mind, it goes too far and completely takes the tools away. Oh, we're told, read the bill, they're going to be able to still participate. Yes, under the express provisions of the bill, our DAs and police agencies will still be able to participate. The practicalities, though, of how this bill works say, as a practical matter, they can't. It's no longer economical. It's no longer feasible. It no longer will be a tool available to them in practice, even though the language of the bill says they can still do it. They won't be able to participate. And that's one of the reasons I think the bill just goes too far in eliminating the tool completely, as opposed to dealing with the very real problem that it is ostensibly attempting to address. One last point. We hear about the difference between California law and federal law, and we've got to make sure that this is happening under California law, not federal law, and those distinctions are absolutely irrelevant. The Supremacy Clause of the Constitution says, beyond doubt, federal law is California law. There is a legal framework. It's in place in federal law. There's one in California law. In either event, it is our law that our DAs and our police agencies are supposed to follow. Let's not take the tool away completely to go after some bad actors. And unfortunately, that's what this bill does in trying to get to the right place. It ends up in the wrong place, and no amount of hand-wringing and saying we've got to follow California law, not federal law, really gets to the nub of the problem. Both of those are our laws, and we should make sure our DAs and our police agencies have the tools to enforce those laws, and then we should supervise and make sure in oversight capacity that we don't exercise often enough that they are, in fact, satisfying the fundamental principle, no innocent person loses their property, and also that they're doing what we ask them to do to protect us. This bill is close, but I just don't think it's there. I urge you not to take the tools away from the police folks. Let's leave the tools with them, and let's come back next year with a more tailored bill that really addresses the problem. Thank you.
Assemblymember Christina Garcia.
Members, I rise in strong support of ABS 443. I actually don't, I have to disagree with my colleague from Orange County. This does not take away a tool, and because it makes it a little more inconvenient, it's not a good enough reason for us not to vote for this bill today. There's not a lot of statistics out there about agencies and exactly who this policy is affecting. It's hard to get that information, but there have been a number of investigations, and the conclusions have been the same. It's minorities and persons of low income who are the most affected by this. This is alarming because we know that in these communities very often we cannot afford legal help necessary to get their property back. There are numerous examples of those who have fought and they have spent thousands of dollars to have property returned to them. Property that was confiscated without anyone ever having to prove that a crime was committed. And essentially, confiscated cash and property are being used to backfill local law enforcement budgets. Current asset forfeiture policy have been turned into a de facto tax on those who can afford it least. The current policy incentivizes abuses and lacks transparencies. For these reasons, I urge everyone to support this measure.
Ms. Weber. Dr. Weber, you're recognized. Dr. Weber.
Yes, Mr. Speaker and members, I too rise in support of SB 443. I had not intended to speak on this bill, simply to vote for it because I thought it was a common sense bill. But I sometimes become confused on this floor because those of us who supposedly believe in the law, create the laws, make the laws, and then give an allegiance to the Constitution of the United States have a tendency to ignore the most fundamental principle that all of us are innocent until proven guilty, and should not be treated as a criminal if we have not had basically a fair hearing and been proven to be guilty. The fact that money is taken, that it can be used for good causes, good means, is no reason to violate my basic principle that I am innocent till proven guilty, and that no one has a right to seize my resources and to use them for whatever good you may want to use them for without my permission, without having been proven guilty. That to me is very fundamental. That's what we do in America. That's what the principles of America are really about. But even if you don't understand all of that, your mother told you 2 wrongs never make a right. No matter how you look at it, as those have told me the wonders that are used by the resources and how the police department needs the resources, I always ask the one question: is it right to take my resources? Is it right for you to go in someone's place and to take their property, to seize their objects without actually having proven that they are guilty of a crime? And we know the answer is always no. It is not. But it's used for a good cause, which is inadequate. It's not a good answer. And so I strongly suggest that we support SB 443 because it really talks about restoring our basic principle in this country, that we have a right to have our property and we have a right to due process, and we should never be treated as a criminal until we have been proven to be so. I respectfully ask for an aye vote for SB 443.
Mr. Cork, you're recognized.
Thank you, Speaker and members. Just the facts. Just the facts. The fact is, if a local California agency wants to participate in a federal task force, they not only can participate, but the money will be seized under federal laws, meaning it doesn't require a conviction. So you can get the money whether the people are innocent or guilty. So that part of the unfairness of the system still exists. What this bill does is says if this is purely a California investigation, then the distribution will be only done under federal law. You can still seize the assets. You have that tool, but the forfeiture only occurs if there is a conviction. That's the difference between federal law and California law. So, federally promoted investigation, fine, happens under federal law. Feds are not involved. What has been happening recently is that the California agencies will then ask a federal agency to adopt the case. That's what this law stops. It says if it's a California investigation, it's going to be California law. Federal investigation, which is a very high percentage of them, you still have the unfairness. Let's make the California investigation fair. Allow seizure, but forbid forfeiture unless someone is actually found guilty. Thank you.
Mr. Cooper, you're recognized.
Mr. Speaker and members, I rise reluctantly. State and local law enforcement cannot send forfeiture cases to the feds to avoid California law. The feds stopped accepting transfers under the federal adoption process in January of this year. Now the only way for a case to proceed under federal law is if federal agencies are actually involved in the seizure. There is a due process under existing law. In civil forfeiture proceedings, the burden is on the government to prove that the seized property/cash is a fruit of some legal activity. That's true whether there is a criminal conviction or not. Further, under current California law, a criminal conviction is already required for any cash seizures under $25,000. We have a wage earning statements. Everyone that works here, you can call EDD, and they will tell law enforcement what your wage earning statements are. These folks involved in the drug trade don't have wage earning statements because they're getting their profits illegally. I've done that before. That is how it works. California right now is the marijuana capital of the country. People come here with tens of thousands of dollars in cash to buy marijuana and take it back to Washington, Colorado, and other states. There are interdictions going on right now at the airport and the train station. That is a fact of life. And really a common sense thing is, how many folks carry around $25,000, $30,000, $40,000 on their person? Hardly anybody. Those folks are involved in the drug trade. It's very lucrative. That's why people do it, to make money. And there's a big process for this, and that's one of the things. Asset forfeiture works. It's a good tool. I've used it. And like I said, the smart ones you don't catch rarely. It's the dumb ones. So to me, this is a tool. It's one of many tools in the law enforcement box, and it really helps it. And lastly, I have a letter, permission to read, Mr. Speaker.
Without objection.
From the International Faith-Based Coalition that represents 5,000 inner-city houses of worship, churches here in California, and they oppose the bill because it affects their communities. Yeah, it affects communities of color. A lot of these drugs are served in communities of color. But the bottom line, in having worked that, it really impacts them the most because the violence, the crime, the gangs, they're all in those neighborhoods, and some of those folks can't lead a life because of shootings and drug dealing that goes on in front of their house. So it really is a critical issue.
Seeing and hearing no further debate, Mr. Alejo, you're recognized.
Thank you, Mr. Speaker. I also rise in opposition to this bill. And this was an issue I worked on earlier this year. I had a counterpart bill with the same number. It was AB 443, but it was targeting some of the most ruthless criminals in our community. We're not talking about moms or dads or community residents. If all of us are serious about really going after the people who are responsible for the most violent crimes, the drug trade, the organized crime, the most powerful way that you can hit them where it truly hurts is through law enforcement tools like these asset forfeitures. The bill I crafted with the support of law enforcement would have gone after those who are dealing with drugs and violence on an international level. But yet that bill was held in the other house. And I think it's unfortunate. Just yesterday in my community, I had a 16-year-old that was shot. The week before, we had 4 other shootings in Salinas in my district. For the last 4 years, one of my cities has had the highest youth murder rate per capita in the state of California in my district. And every week that a young person gets killed because somebody ordered somebody to be hit, or called out some crime to be through some order that came out of some prison somewhere. There's a mother who lost her child. The community's hurt. And we always say we should go after those gang members. We should really hit them where it hurts. This is what this bill is about. You would take away one of the most important tools to deal with those folks who are creating havoc and who are creating murders and other violent crimes in your own districts. So don't be fooled by the rhetoric. This is an important tool for law enforcement. We need to keep this tool if we're serious about addressing the crime that is happening in each of our districts all across the state.
Seeing and hearing no further debate, Mr. Hadley, you may close.
Thank you, Mr. Speaker, and thank you, everybody who spoke on this important topic. The 14th Amendment has been in the news a lot lately. The first sentence of the 14th Amendment has been in the news a lot lately. Let me read the third sentence of the 14th Amendment. No state shall deprive any person of their life, liberty, or property without due process of law. This is not a more complicated issue than that. I don't like being on the opposite side of a bill relative to our law enforcement professionals. I have a great deal of respect, I have a great deal of gratitude for the hard work that they do to keep our communities safe. But it is a core principle of American justice that each person has his or her day in court before his or her property is taken. And what this bill does is it restores that core principle in an area where federal policy has deviated for 30 years and where California policy has been good for the last 15 years. This bill does not change California law. It simply ensures that California law is followed by state and local law enforcement professionals rather than using federal law to split asset forfeiture proceeds that are gained without a conviction. This bill is, again, it is supported by a very broad spectrum from the LA Times to the Wall Street Journal, from the ACLU to the Heritage Foundation, and that's because this addresses a core principle of American justice. I ask you to vote for justice. I ask you to vote for SB 443.
This time, the clerk will open the roll. All members vote who desire to vote. 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 Mr. Hadley, what's your pleasure? Move the call. Mr. Hadley has moved the call. We're going to go now to, we've already disposed of file item 100. We're going to move to file item 101, SB 794. The clerk will read.
Senate Bill 794 by the Committee on Human Services and Act relating to Child Welfare.
Assembly Member Kansan-Chu, you're recognized.
Thank you, Mr. Speaker and members. SB 794 is a Senate Human Services Committee bill that implements House Resolution 4980, the Preventing Sex Trafficking and Strengthening Family Act. This bill will make California comply with the federal requirement pertaining to child welfare in order to ensure Title 4E allocation for child welfare services, which is over $1 billion annually. I respectfully ask for your vote.
Seeing and hearing no further debate, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tie the votes. Ayes 62, no 0. Measure passes. Colleagues, I have an announcement, quick announcement. All members of the Rules Committee will meet immediately at this time in the Rules Committee room. Again, all members of the Rules Committee will meet at this moment immediately in the Rules Committee room. Please follow the Rules Committee chair to the Rules Committee room at this time. Moving to file item 102, SB 804. The clerk will read.
Senate Bill 804 by the Committee on Health and Act relating to Public Health.
Mr. Bonta, you're recognized.
Thank you, Mr. Speaker and members. Today I present the Senate Health Committee's Omnibus Bill, SB 804. The Health Committee's Omnibus Bill makes technical changes in addition to providing clarity to more substantive actions recently undertaken by the legislature. Thank you, and I respectfully ask for your aye vote.
Seeing and hearing no further debate, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tie the votes. Ayes 55, no 0. Measure passes. File item 103 will pass and retain. We've already disposed of file items 104 and 105. File item 106 we will pass and retain. Moving to file item 107, SJR 10. The clerk will read.